Breaking news, Ban Chairman Wontumi has been found guilty. A Sibu also. And today, I don't know how to feel about all these things because Obi Awasha channel ya cha obeka credit. I kept saying say Yamompire ma Chairman Wontumi. And then for the first time I have the clearance, I'll give you the ruling, but the link in the better description bar no. To the ruling of the submission of no case, no. Sa dear no na me kan me ka say Yamompire ma Wontumi no. 31 pages. Tiwa be kind no better description bar no. O kind from the 10 page kwa. O be always am about kakra because I'm quite sad for him. And not because maybe you answer me because me pen answer, but when you read the law, it was quite clear. We are live in the court as I know say my senior colleague I'm replacing is a producer for Love FM was Wood or the court. So near Kosubiana Medema Biani exclusive from the court. And they're making kind on the Facebook page, and it's not different from the ruling in the submission of no case by Judge Audrey Kokuvite. Ni din minim sasane bona medunim Kokuvino te or not nasam no so. Breaking news at Airbana say most na yera attaching at the court wabato atwene. Or say mrebi anywhere chese constitutional bibia there be confusion be any message Supreme Court be not so wabato atwene. Enti ye become exclusively sentence name by a convicted Wontumi. Te ye na say eyedan ya Wontumi will go to jail. Mene wo kasay answer na meba no na the lawyer ejina na so all mitigate all say Wontumi a first time offender yente so mano. But Catherine say when you read the Minerals and Mining Act as amended 995 no say 703 and no na 3 years no we illegal mining na 995 na prenya kufa da mani 2019 no me call 25 years. Ana me Catherine say Occupy Ghana letter be or true na minim da 2022 tano minim case no car say the same Minerals and Mining won't make me go jail 25 years. So that was the day me discover and say hey and at the any man hu I'm a trust 25 years won't me to go to Japan for bedi di matter has a video no. So the Minerals and Mining Act no 1992B no won't me bet me go jail. One shot by the time I meet video na term number between 15 to 20 when you the least term kra no 15 years. So that is the news coming in from Chairman Wontumi because he's been found guilty. But me no be but I'll go with you systematically. Maybe people will how do I call it? We'll get it today. And to make sure also subscribe. Most subscriber no click the notification. The video be to you will certainly have a comment. Feel free leave that comment in the comment section. We are make sure so because Goldberry construction method and episodes on assassin character some of the documentations related to your house and Goldberry in the bedi stage man in Adiaman because it's a live court process and make sure me phones were I'm just taking updates so that I can give it to you. Now you're starting to say Wontumi is not being charged for Galamsey. Those a case the day Samreboi Galamsey ke benye Galamsey. Asem ni nyina na say aban ama Wontumi asase a wode ye mining. Ana ban say nkrofobia ko Wontumi asase ne so akoye illegal mining. Wontumi response ne say ma mo kwan ankoye illegal mining. Meme mo kwan so mo nkodua kube. Ana ban say so mo kwan kra so mo nkodua kuba. Based on section 14(1, esa wokoje minister ni approval. Now section 14(1 ka say anytime ode aban ana concession bi aban the concession amount. Now once would mo bi na esa wokoje permission. Now let me quote the right law for you systematically so that you understand everything in this video. Or say a mineral right shall not in whole or in part be transferred, assigned, mortgaged, or otherwise incumbent or dealt in a manner without the prior approval in writing of the minister. It's a buying kase Wontumi akoye Galamsey or say assassin the man crofon ogum a ono no be di adanse ma state ni sampa Wontumi di assassin man no meba so or say una di assassin man no so akoye Galamsey kura akoye Galamsey ya ansa na di assassin kura be man no keso okoka kire minister Samuel Bujina po no ma letter sa letter no way Wontumi so ni letter no ba ne one ne kan ne so nkodua kube reclamation na ono Wontumi so good ni papa pension so ko bo Western Regional Security Council no amane because Samreboi or Western region na ne kosi ye ne enti ade ne meka se mompa eme Wontumi ayade bi ekosi was submission of no case nim ma me ma court there now link it for you. Judge ne ma ne analysis of the case no asamba akọ kan ye ne tie ne ye o say is currently reading Mamin Kaima. Just give me a second. I'll just do that for you. Yes, this one. The judge said that, listen, says analyzing the circumstantial evidence, Chairman Wontumi permitted WPW, which is prosecution witness, to mine his concession. Chairman Wontumi saying the agreement was rather for reclamation was an afterthought. It was say, Wontumi ka say onim hu bi say as nipa no ka so nkoye reclamation or koye galam no onim hu bi a afterthought, because and can we follow the right process, and maybe the state would have also been in the known of that and even exonerated you on that bit of it. That's what I say. Owie na judge na so kan say Wontumi call court no okoka kire court say corporate view no ade akontaman ne omo managers ni ade enyo ono ano. This is what the court said. The court said that yes, the ruling. Or say, in dealing with lifting the corporate role to prove who truly is the owner of the mineral rights, she's dealing with the cross-examination on Wontumi and other minors. Or say that the cross-examination of Chairman Wontumi by the deputy AG shows bad corporate structure and governance adopted by Quantum Mining. Wontumi says he does not know where the other director he was running the company with had run to. Just say, what's here Wontumi here? Now what's your testimony na bra deputy engineer and crosses? I say a Quantum Mining as a good deal or hododo. As a boys name, I also need proper structures on the juma. Now had they or say after analyzing the cross-examination of the deputy AG, Chairman Wontumi, Justice Odite said that Wontumi was and is the true holder of the mining lease. It is a contaminant you and the one lease no said then or the analysis ni no share exchanges between deputy AG and Wontumi the one a bra or no cross-examination na Wontumi na lease nankasa ye ne dia. Now this is where I did me can say Mompayema Wontumi no. This is it. Now I'm reading the submission of no case for you. When you read from the page 11, the court says something that I think that was very, very instructive. Let me read for you from the 11. This is what the court said from the page 11. Let me just read it for you here. Just a moment. Yes. Now every count here Wontumi no. So let me give you the count before I come back to the analysis. Let me just give you the count. Forgive me, it's a live case, so let's all relax and take a system. Count 1. Assignment of mineral rights without approval. And I'm on section 14.1. Count 2. Assignment of mineral rights without approval contrary to section 14.1. And section 99.2b. 99.2b na dem read mass I know you broad instigate, procure, solicit. In fact, the 14.1 no it is under the 99.2b. It's in a judge and I can say don't say punishment in the 14.1b no and section 59 no. So punishment because of the broad nature of 99.2b no, the punishment can be found there. I mean read this submission of no case and so no kind of amount. Yes. 3 no, assignment of mineral rights without approval. It was yen charge Wontumi for Galamsey. Charges nti purposely facilitating an unlicensed mining company contrary say wokofo bi so wo medi dwuma bi wo wastars so say illegal mine akra so make sure say for example Anglo Gold ekofa Mahama Anglo Gold that said yes so mo say Mahama a license so timi offer mining support services. Count 5 from purposely facilitating an unlicensed mining operation. 6. Purposely facilitating an unlicensed mining contrary to section 99.2b. In fact, and the court and the finance say, Wontumi ema my reclamation na one mark one sika. No person sa one man is kind of crack say onumsa kwan be Galamsey de this edwuma. Court no so sa can say George Odite ya no pay maybe your life process aka say Wontumi evidence attorney general check Wontumi to excavate said the man nkrofo no. It ni na evidence or they are convincing Wontumi on count no. Into on count 1, 2, 3, 4, Wontumi has been convicted and found guilty. Now, you go back to the submission of no case. Who said to every count they give you, there's element of crime. It is a murder. The intent, then the memo be able to trim so be murder. See, a cassia charge you be murder. Ingredient ben ye first to just so murder. Ye jollofa. And yema ben a kick up moon said jollof. A moon a stew. A be a mackerel. Ye be a goat meat. Ingredient in a manner jollof ne there. Now had there. Judge and ma ruling no page 50 me the link in the better to meet me chance and that's our editing the bewa. Or say essential element of the offenses charge. Ti away submission of no case. Abra Attorney General in the case of Wontumi case on kasano. Judge ni ruling say Wontumi be kasa na say on kasano. This is something he said, and it's very instructive. The 31-page document. I'll say, the first of the two counted offenses which the accused persons are charged with is Section 14.1 and Section 99.2b of the Minerals and Mining Act 206 as amended by Senator McCann 995 of 2019. And I'll say, already here, or say at least 3 elements may be deducted from the offense. Possession of a mineral right. That's what we possess a mineral right, yes. Dealing with the mineral right, that the accused person did any of the following acts in respect of the mineral right transfer, assigned or mortgage in any of the other manners incumbent or deal with the mineral right, and lack of ministerial approval. So the only time you can charge Wontumi 14.1 and 99.2b, they say 3 elements. Nipano or lease was assassin. 2 or lease no oye ne den assassin oye ne sen. So what transfer ya or minister ni approval na all these 2 elements or 3 elements were proven. So this is the element on which the judge is convicting Wontumi on the count charged. Me pacho what you say. Now when you go to the same 41, made the link but you can read it for yourself. Or the second count, 3 elements. Absence of a penalty, that the act does not specify a penalty to such a contravention. What's a 41 a penalty? Okay. And also 2, abetment by the accused person, that the accused persons acted or instigated, commanded, counseled, procured, solicited, aided, facilitated, encouraged, or promoted. To you say to me, Kodiboni, now, okay, it can be inferred as procured, it can be inferred as facilitated. I can't say 2019 amendment, the way I hear, sir, 1992 be a brother, when you're there, bet you. Because certain Galamsey na betu, henya. It's a prayer go for no parliament, me from 3 years to 15 to 25 years. Now, in fact, 99.2b, my main time out, then you understand it. Then maybe by the time I hear me phone, so you are not judgment and about. Then I'll give it to you. 99.2b, this is it. This is the 99.2b. Into share my mema 206 there, 206 that Galamsey gidi sa. It's not 206, Say na 99.2b. It was say a person who acts in contravention of this provision of this act in respect of it an offense has not been specified, commits an offense and is liable in summary conviction of a minimum fine of 1,000 penalty or a prison term of not more than 3 years or both. 2006. 2019. Afiti where they or say a person who acts or instigate, command, counsel, procures, solicit, or in any manner purposely aids, facilitate, encourages, or acts or promote any act in contravention of a provision of this act in respect of it a penalty has not been specified, or contract a non-Ghanaian to provide mining support services, commit an offense and is liable on summary conviction to a fine of not less than 10,000 penalty unit and not more than 15,000 penalty unit, and to a term of imprisonment of not less than 15 years and not more than 25 years. This was the undoing of Wontumi. This was it. This was the doing of Wontumi. This was it. So, breaking news and say Wontumi, the lawyer is still on his feet. He's still on his feet, and his advocates say Yema Wontumi the minimum sentence, which is the 15 years, And I think that even when they got the minimum sentence, they will appeal. So for me, it's a very, very troubling news for Wontumi, certainly, and people within the MPP. But as they always say, the law is the law. So that is that. All the count guilty and convicted. And when the full document come from the court, we will do the analysis for you. But I'm going to say, even before the analysis comes, when you read the submission of no case ruling now, and I kept saying this thing, it was so clear. The judge, and in fact, submission of no case, our high court, and and the appeal could be finding issues with Mahama, or the a court appeals court or can say, I don't know, Mahama conclude this statement or can't say. Evidence now 20 general proven so Wontumi na no ho a we guilty no, but na my lawyers also catch them and say submission of no case na say judge and Jane saying you so where so be answer. That's the only thing the judge will say. That based on because the submission of no cases says that nipa no bo kwadu no. As me you just say to because me we are there. E say wona wo evidence me we are there. It would evidence but me you just say because asem kan there ohene ana judge akwa asem o kenyansa ni mu. And on the submission of no case. He said judge ni rule because there be Eugene. Yes we are microphone. Microphone ingredient just say we are say e bia tracker no. Ye tracking e bedu o dem. A element my can be keke. Ebia rubber ye shehu ye buy na microphone kwa ba rubber no so be hu bi wo dem. What I say? Intimidate say when you hu ano a asam no bobati anti you hu ano. Eno na nkyere say judge na ka say we ye guilty o. Or ka say based on the evidence provided say wo so ama me an answer to refute or to rebut or to give me extra information why these things are in your possession. It may seem as if you are guilty. Now, in fact, in the submission of no case, judge, analysis be in the matter. Let me get the analysis for you. In fact, this is the conclusion statement. Then maybe I'll end the video when the matter comes again. I'll do that for you. Or say, from the above discussion and having considered the charges, the facts, and the evidence so far adduced by the prosecution through its witnesses, and the submission for counsel for Wontumi and Akonta Mining, and that made in response by the public counsel, contrary to the submission of Wontumi's counsel, and the prosecution has not made a sufficient case against Akonta Mining, I find and do hold that on all the offenses charged, there is a rebuttable presumption that Wontumi and Akonta Mining have committed the offenses charged. Otherwise stated, the prosecution has by the evidence adduced made a prima facie case against Wontumi and Akonta Mining on all the offenses charged. This was after the judge broke all the count 1 ingredient in the element, count 2 element in here, count 3 element in here. Or see, based on that analysis, Wontumi was something to answer. So for me, I think that the submission of no case, was clear in me you say to me view. It was very clear. It was very clear for me. So unfortunately, Wontumi has been convicted. The years, I cannot give you the years now because that is not public yet. As and when that is public, and certainly I will give you further and better particulars on it. As at the time I may sign it out. As at the time I may sign it, let me look at the time. As at Council of Filigama and takes notice of the first and count 1, count 2, sentenced to 20 years. Wow! Aba. It count 1 and 4. Chairman Wontumi has been sentenced to 20 years. 3 years in default. Both to run concurrently. Hey. Wontumi aswaya shit. Wontumi come 20 years. What does this mean? Let me quickly test my lawyer to explain this for me. A life for you to move venture me wine pacho. Life. Let's all learn the lessons in there. That's the most important thing. The judge said that the law was enacted to deal firmly with illegal mining because of the serious harm it causes the environment. The judge also notes that this was Chairman Wontumi's first conviction. On count 1 and 4, the court found Chairman Wontumi guilty. For each of the 2 counts, the court imposed 20 years in prison and a fine of 10,000 penalty. If the fine is not paid, he will serve an additional 3 years in prison instead of paying the fine. Both sentences will run concurrently, which means that he will not serve 20 years plus 20 years, 40 years. He serves both 20 years at the same time. Therefore, the effective term is 20 years, not 40 years, assuming the conviction stamped. So instead of 20 years for count 1 and count 4, 20 years for both count 1 and count 2. So in short, Chairman Wontumi has been sentenced to 20 years imprisonment and fined 10,000 penalty units on each of the count 1 and 4. The prison terms run at the same time, so the total jail term is 20 years. If the required fine is not paid, a default prison term of 3 years is applied in place of the fine. It is so fine. So the fine when 3 years about the count. That is my reading of the law. If I'm wrong, feel free and correct me. So that is the breaking news there. But Wontumi ekum for 20 years. Wontumi ekum for 20 years. So that is that. That is the breaking news coming in. That is the breaking news coming in. Very sad news that is coming in. That's a sad news coming in. So count 1, count 4, plead guilty 20 years. I think that it will be concurrent for most of the. I don't think they will do 20 years. They may be all the count of the. I think that will be 20 years. So I think that I can conclude here. But as and when they are further better particulars, you can monitor my updates on Facebook, or I may do a video. I'm also update on the Facebook community post. So that is the news coming. Wontumi is going to jail, but he can appeal. So it's not like it's a finito thing. They can appeal to the appeals court, and I think that even all the way to the Supreme Court. I stand to be correct, but appeals court, I know that he can go to the appeals court. Cases where and they appeals court. For example, a parliamentary election petition, it doesn't go to the Supreme Court. It ends at the appeals court. And see, what I know is that he can appeal this to the appeals court. For Supreme Court, I don't know. I won't pretend to know, and I don't have. My lawyer is offline now. So that is that. Yes, it's concluded. So Wontumi is going to jail for 20 years. 20 years. You are fine, no. When you are fine now, 10,000 penalty unit. I have to calculate it for you. When you are fine, or somebody could jail 3 years. That is the breaking news coming in. That's it. It's any further better particulars in the bedroom. Subscribe it for me. Now we are watching Ghana.